I'm Nate Eaton, and I'm chatting with Bonneville County Prosecuting Attorney Danny Clark. He's been the prosecutor for quite a few years, and I wanted to ask him a few questions about preliminary hearings. Now, Danny is not associated with the Daybell case at all, so he's kind of providing an objective viewpoint for all of this. But Danny, the number one question I've been asked ahead of this Chad Daybell preliminary hearing on Monday is, what is a preliminary hearing? How do you describe what's going to be happening on Monday?
Sure. Let me just take a step back and give you the backdrop and then speak specifically to what a preliminary hearing is. A defendant in Idaho can be charged one of two different ways, either by an indictment that a grand jury would bring or by a criminal complaint. Now, if they're charged by a criminal complaint, which is fairly typical in this state, a defendant is entitled to a preliminary hearing within a very short period of time. If they're in custody, it's usually within 14 days, but on a homicide case or a bigger case, that usually takes a little longer. So they're entitled to this preliminary hearing very early on in the case. A preliminary hearing is where a judge in open court makes a determination whether there's probable cause. More specifically, the judge determines whether an offense was committed, whether a crime was committed, and whether the defendant probably committed that crime. Anytime you charge someone with a crime, the state has to prove, 4, 5, or 6 different specific elements. The court will be looking specifically to whether each one of those elements is satisfied. But again, it's just to a probable cause standard. Now, when a defendant is generally charged with a crime, if the judge issues, say, for example, an arrest warrant, you've heard of that or you've seen that, yeah. Well, the judge makes a probable cause finding at that time also. But this is the first time where it's in open court in front of the defendant and his or her attorney, and the defendant has the right to vet or otherwise challenge that evidence in some way. And so this is the first time the defense is involved in that probable cause finding.
But it sounds like the burden is on the prosecutor. He's got to go through and say, this is what I have.
Correct. Well, to some extent. Let me make sure and say this. First of all, it would be very unlikely for the defendant to put on any evidence at all at a preliminary hearing. Very, very uncommon. In fact, even if they have some, they generally would not put it on. So it's always the state that's putting on the evidence at a prelim. Also, I would say this. A preliminary hearing is very, very short in comparison. Let me give an example. On a homicide case, a preliminary hearing may take 3 hours, whereas the trial might take 2 weeks. That gives you an idea, but also some of the structure of a trial process, but also the amount of evidence the state would put on at one hearing versus another.
But we do know, at least from Monday's hearing, that a few people have been subpoenaed and will be appearing, as a witness there. But you're saying it's not going to go as in depth as the full trial will eventually do.
Well, I'm not going to speak to that. Sure. I have no idea. But yeah. I would be very, very surprised if the state put on all of their evidence, because they just simply don't need to. The obligation is to put on sufficient, competent evidence to show that the defendant probably committed the crime. That's the legal standard. And I would imagine the prosecutor would put on something to that effect. Speaking of the subpoenas, that's the typical process to have someone come into court. And so there may be people that are subpoenaed that may not even be called as witnesses. Again, I don't know. I'm just saying that it's not uncommon for subpoenas to be issued, and some people are called to testify and some are not, just depending upon how it plays out.
So that'll happen at the hearing. Let's say the judge says, okay, there is enough probable cause that this crime likely was committed by the defendant. What then?
Well, we got to remember at this point, the case is still in magistrate court, okay? A felony is to be heard by a district court or a higher court, but a complaint starts the case in magistrate court. If the court determines there's probable cause, the court will bind the defendant over to district court. It's just a legal phrase to have them stand for charges in district court. After the preliminary hearing, if the court finds probable cause, The district court will then have an arraignment hearing where the defendant will have his or her their first chance to either plead guilty or not guilty.
And then if they plead guilty, they could be sentenced and there's no need for a trial. If they plead not guilty, then that trial date is set.
Yes. But I would imagine, a not guilty plea on any case of any magnitude is generally the process at this point, just based upon the timing, size of the case, things of that nature.
So just so we have it straight, this preliminary hearing happens. If the judge says, yeah, there's enough probable cause, it advances to the district court, which then the defendant is arraigned. Is that what you call it, an arraignment?
That is correct. They
plead guilty or not guilty. And then it advances to a jury trial. But that's not going to happen right away, right? This is going to take some time.
Yeah, I can't speak to this case or its timing, but typically a homicide case, you're 12 to 24 months under the best of circumstances for those to come to trial and to come to some completion, and that's without any delays.
So the question that many people will have is, well, why does it take so long? Why can't they just go before the jury in 2 months and get it done?
Back in the olden days, that used to be, they'd have something happen in the morning and they'd impanel a jury in the afternoon and they just get right after it. Look, we got to remember, at its core, this is the intervention, or this is a government body intervening in someone's life and affecting their personal and individual rights and their civil liberties. The court and the rules associated with what the court will do is going to take the time that it needs to ensure that everything that needs to be done on the case is done to protect the rights of those that are accused. That's the demand the system puts upon the state, and rightfully so.
Is there anything, Danny, as a prosecutor, that you want the public to know, any misconception out there when it comes to these cases where people think that the wheels of justice need to move quicker and happen right now? What would you say to the people that have been following this and other high-profile cases?
Well, from my perspective, the case is since the things really came out and the investigation really got moving. In my perspective, the case is being handled quite well. It does take some time, and that can be difficult on a news media outlet that wants to run some new things. Victims' families that are connected to the case, that's difficult. But again, we've got to balance that against the government's the demand on the government to ensure that everything's done just right with respect to that defendant. And so those things do take some time, and certainly patience is appropriate. Another thing I would mention as a side note, if that's okay,
Please.
Is a prosecutor cannot sit there and speak to the case. And so another thing I would want the public to know in general is there's different people and there's different pundits that will speak about the case itself, but the prosecutor cannot. He or she is prohibited from speaking to the media about a case while it's pending. And so while there might be lots of questions that you want to know and frankly probably deserve to know, they cannot speak to those things while the case is pending under their ethical obligations to the defendant and to the court.
As much as we want them to.
Yeah.
They cannot. And that's why we appreciate you coming on and kind of answering some of the questions. The legal system, for those not familiar with it, can be daunting, and a lot of crazy terminology that we're not really familiar with every day. And so that's what's going to happen during these preliminary hearings coming up. Don't expect a not guilty or a guilty plea. Don't expect everything to be resolved in the next few weeks. This is a long haul. I've heard the justice system can slow things down just to be sure that, as you mentioned, it is fair for everybody.
Sure. And
Danny Clark, thanks so much.